Welcome back to the Two-Way Report. Chevron deference is the power held by the ATF and other agencies that allow them to freely modify regulations without congressional approval. Recently, the United States Supreme Court has taken up a case aimed at overturning this power. The kicker? This case doesn't even concern the Second Amendment, but it will help us greatly if the Supreme Court decides to kill Chevron deference. In this video, I will discuss the case and its potential impact. The potential ramifications of the recent decision by the United States Supreme Court to take up the Loper Bright Enterprises v. Gina Raimondo case are significant. In the past few years, the Supreme Court has discussed issues that have come close to dismantling Chevron deference, a power wielded by all federal government agencies to change regulations without the need for new laws to be passed by Congress. However, until recently, the court did not believe it had the necessary votes to eliminate Chevron deference entirely. Now, with the Loper Bright Enterprises case, many legal experts are predicting that this could be the case that finally leads to the destruction of Chevron deference. Again, the case at hand isn't in any way a Second Amendment case. It concerns, get this, fishing, of all things. The case challenges an NOAA fisheries rule that requires Atlantic herring vessels, fishermen, to hire third-party monitors and pay as much as 20% of their revenue for that third-party monitor to collect data for conservation and management of the fishery. The outcome of this case will have far-reaching implications for regulatory agencies across the board. And we, Second Amendment rights advocates, all stand to benefit. How will we benefit from all this, you may ask? Well, the actions of the ATF under the Brandon administration, including this agency's implementation of the pesky bump stock ban during the Trump administration and previous policies under the Obama administration, are all carried out under the legal concept known as Chevron deference, which exists as a somewhat ambiguous area. But what is Chevron deference? You've heard it here on the channel a ton of times, but we've never really talked about it much. Chevron deference is a legal principle that originated from a 1984 U.S. Supreme Court case, Chevron USA Inc. v. Natural Resources Defense Council Inc. The case involved a challenge to a regulation issued by the Environmental Protection Agency, or EPA, that allows Chevron to use a particular method for calculating emissions from a plant. The National Resources Defense Council, or NRDC, argued that the EPA's interpretation of the Clean Air Act was incorrect and that Chevron's emission should be calculated differently. The Supreme Court ultimately sided with Chevron and upheld the EPA's regulation. The court established a two-step framework for reviewing agency interpretation of statutes. Under this framework, courts must first determine whether Congress has directly spoken to the precise question at issue. If so, the court must give effect to Congress's unambiguous intent. However, if the statute is ambiguous or silent on the issue, courts must defer to the agency's interpretation of the statute as long as it is reasonable. Chevron deference has since become a central principle in administrative law, shaping the relationship between agencies and the courts. The doctrine has been used to uphold a wide range of agency decisions, from environmental regulations to immigration policies. However, it has also been criticized for giving too much deference to unelected bureaucrats and for infringing on the separation of powers. The Supreme Court has revisited and refined the Chevron framework in subsequent cases, but the basic principle of deferring to agency interpretations of ambiguous statutes remains a cornerstone of administrative law in the United States. Now, we're not exactly haters of Chevron deference here. We really only hate how the ATF uses it and abuses it. Chevron deference has both advantages and disadvantages. As far as its advantages, I can think of three. 1. It increases flexibility and adaptability. Chevron deference provides agencies with the flexibility to interpret and implement laws in a manner that adapts to changing circumstances and situations. 2. It facilitates efficient policy making. By granting administrative agencies the authority to interpret ambiguous statutory language, Chevron deference allows agencies to issue regulations and guidance more quickly and efficiently than if they were required to wait for Congress to pass new laws. And 3. It rewards expertise. Some agencies may have specialized knowledge and experience that can be used to interpret complex laws and regulations, which can lead to more informed decision-making. But all of those advantages are only advantageous to whichever agency is using Chevron deference. To us civilians, it has 3 major disadvantages. 1. It is subject to abuse. Agencies may abuse Chevron deference to push through their preferred policies, even if those policies may not align with the intent of Congress or the Constitution. 2. It infringes on separation of powers. Common sense dictates that Chevron deference can undermine the separation of powers, as it allows the executive branch to make and interpret laws without sufficient input from Congress. And 3. It creates uncertainty. Chevron deference creates legal uncertainty by allowing agencies to change their interpretations of laws over time. This can make it difficult for businesses and individuals to know how to comply with the law. So, as you can see, Chevron deference is pretty much a communist tool. The application of Chevron deference has had a detrimental effect on the American system of checks and balances, leading to an executive branch with less accountability like Biden's. Chevron deference also leads to an excessively dominant bureaucracy and uncontrolled regulations by, again, let's go Brandon. If you saw Stephen Dettelbach's testimony when he was being grilled by Congress, did you notice that he frequently cited Chevron deference? The current legal consensus suggests that if Chevron deference is killed, it's like the ATF is castrated. For instance, Congress has already established the definition of frames and receivers, and they are unlikely to modify it to accommodate any idiosyncratic notions. The ATF with no Chevron deference is like a chicken with its head chopped off. All flip-flops will end, including the pistol brace rule. And it would also limit Sleepy Joe's ability to enact changes through agency regulations, as his appointed directors will not have the power to pass legislation without Congress. If the ATF did not have the benefit of Chevron deference, they would not have the power to implement the recent pistol brace rule. Heck, they wouldn't have been able to do all the flip-flopping they've done in the past decade. Granted, a lot of our friends filed a case against the ATF to reverse the pistol brace rule, and a judge has already stated that the Second Amendment protects arms such as pistol braces, which means the ATF will ultimately lose. But the whole fiasco wouldn't have happened to begin with if there's no Chevron deference. With Chevron deference gone, it will impede Brandon's ability to utilize administrative power to implement changes without going through Congress first. The significance of Loper Bright Enterprises v. Raimondo case cannot be overstated. But whether or not it will kill Chevron deference depends on the Supreme Court. Last May 1st, the Supreme Court granted certiorari to hear the case, which means they will receive it. The certiorari process entails that at least 4 justices must agree to take up the case, but a majority of 5 justices is required to reach a decision. To give you an idea of how the Supreme Court may approach this case, I would like to present 2 quotes. Firstly, in the previous fall, Justice Neil Gorsuch remarked, quote, "At this late hour, the whole project deserves a tombstone no one can miss. We should acknowledge forthrightly that Chevron did not undo and could not have undone the judicial duty to provide an independent judgment of the law's meaning in the cases that come before this nation's courts." End quote. In 2020, Justice Clarence Thomas stated, quote, "Chevron is in serious tension with the Constitution." End quote. Additionally, the Supreme Court ruled in West Virginia v. EPA that the new administration could not use Chevron deference to circumvent the law's specific requirements. The rulings sent a clear message that regulations could not be used to bypass legal standards, particularly when criminal penalties are involved. So yeah, the Supreme Court has ruled countless times that the Chevron deference cannot be used, particularly when regulations carry criminal penalties. Instead, the rule of lenity should be used. This applies to virtually all of the ATF's actions, which impose severe fines and up to 10 years of imprisonment for noncompliance with their regulations. It's unreasonable to expect individuals to unquestioningly follow administrative orders. Consequently, this case is significant and Chevron deference is likely to be overturned. The Supreme Court has added it to their docket, and it will most likely be heard this fall, with a decision expected within the first half of 2024. The Supreme Court typically announces its decisions in June, just before going on break, after hearing cases towards the end of the year. If everything goes according to plan, we may finally see the end of Chevron deference. I really think that'll be the end of it. And that means the ATF, the EPA, and all alphabet agencies that love to use Chevron deference to abuse their authority, they will all be neutered. If the Supreme Court ends up trashing Chevron deference, it will be huge. I'm thrilled about this development, and although it will take some time to come to fruition, Chevron deference is now dying a slow and painful death. Some justices have been advocating for this change, and this case could finally bring an end to the way government regulations impede Americans' rights through administrative rules. While this case may focus on fishing regulations, it has far-reaching implications for American citizens. Overall, this is a positive development, and I'm interested in hearing your thoughts on the matter. And that's all the time we have for today. If you like these kinds of videos, please share them with your family and friends, and tap that notification bell too while you're at it. Thanks and have a good one.